Hello everyone. Hey, I'm really excited to give you a little summary of a trial that I did along with Jessica McBryant and Randy Manning here at Ramos Law. This case involved, it was a motor vehicle crash. It involved a corporate defendant where their driver, basically with a load on his truck, which I'll get into here in a bit, had slid out into an intersection and had hit our client. Our client was employed by a large grocery store chain, and unfortunately this job that she had required her to be on her feet all day. After this crash, she ended up undergoing surgery, had injections, had a very long recovery, made it difficult for her to do her work, and of course then she sought our assistance. Ultimately, in this case, and I'll jump to the end of this before I give you some of the details, we ended up getting a verdict of a little over $660,000, and by the time attorney's fees and costs and pre- and post-judgment interest were involved, that amount was closer to $1.1 million. Now, the reason that we're very satisfied with that, and our client was as well, is there was at one point pre-trial where we had no offer. Then there was a point where I believe we had $200,000 offer going into trial. So as you can see, we did substantially better than the offer. And I'm going to explain to you some of the things that I think and that were special about working with my team in this particular case that ended up making it successful. So first of all, let's talk about some of the challenges we faced. This case was extremely challenging because of several factors, and some that you might not think of right off the bat. First of all, the other side brought up that Ms. Keller had hired her attorney 3 days after the crash. They used this to make it sound like she was just out for money, she was a money-hungry person. That was a big challenge. Another challenge that we had was after the time of this motor vehicle collision, and before she actually started getting a lot of her care, and kind of when she was in the middle of some of the conservative care, like the physical therapy and the chiropractic and such, she fell down some stairs. And she fell down quite a few stairs. As I recall, it was 6 to 10 stairs. And the way she landed on her left side. She'd hurt her left hip, her left shoulder, and she'd injured her neck. This was documented in medical records. These were the exact same areas that she had injuries from the motor vehicle crash. So again, now we had this pre-existing injury, or kind of an interim injury, I should call it, that had occurred. Another challenge that we faced in this case was that the insurance company had hired a private investigator to basically follow our client around everywhere for weeks on end, and I mean all the time, and try to catch her doing anything that looked like she wasn't hurt. They were so aggressive about their chase of her, as one example, they didn't realize that it was her son in her car who had driven his girlfriend to a park, and they were in the front, I think, kissing or something. And literally the private investigator was recording all of this, not realizing that he didn't have Miss Keller in the car. But as part of this film footage they had excellent footage of her out on a porch cleaning it. And cleaning it, she was, brooming the thing off. She was reaching up above and getting cobwebs down from up above. She was moving stuff around. They had her carrying stuff from her car into her house, a bunch of heavy bags. And in doing so, they noted, of course, that there wasn't a limp, so her left hip couldn't be hurt. They also said that how could she carry bags? How could her left shoulder be hurt? How could she be reaching up and getting cobwebs if her left shoulder was hurt? And they made a bunch of noise out of this private investigator video they had. That was another big hurdle to this case. So as you know, in these type of cases, the insurance company doesn't pick the easy cases on their end, or on our end, and decide to try them. And what I mean by easy cases is this. If a drunk driver hits somebody from behind and that person's injured, the insurance company wants to settle that case and you don't get to trial on it. They will do everything they can do to avoid trial and get out of it. They know that a jury's not going to like their client. They know that they likely caused these injuries. They know that the causation is clear. And insurance companies won't go try those. What they do is they pick what they consider easy cases. They pick the cases where they can blame her work or blame her activity or call her a faker or question the mechanism of injury. And that's what they did here. And that's why we had minimal to no offer. And then kind of after years and years of going through the depositions and the workup of this case, we had, I believe it was that $200,000 offer. Now at that point, it really puts the client in a real conundrum. Miss Keller had already undergone an extensive amount of medical care, so her bills themselves were extremely expensive. She'd missed an extensive amount of work. She had an extensive amount of bills with us hiring experts and prepping her case. So then to settle, a $200,000 offer is almost like offering nothing. To make matters worse, the attorneys in this case were difficult. And sometimes you'll try cases against defense attorneys that are, they're very down to earth, and they're just guys that they're doing their job and they do right by their client, but they're very honest and they're very straightforward. There's no hide the ball, so to say. Other times you try cases against defense attorneys who they're that I want to win at all costs type of guys. That's what we had here. We had the I'm going to win at all costs type of people. And they fought us tooth and nail on every little thing. Everything. As an example, we got to court, and of course they waited until court, and then they fought us saying that none of these medical records could come in or be discussed in evidence because they weren't certified records. We were able to get through that, and I'll explain some of that here. And I talk about my trial partners in this case. We were able to get past that. Then they went to argue that the redactions of the medical records, see, we're allowed to redact, of course, certain private areas of information. It might be social security numbers or dates of birth, or if there's a gynecological issue, for example, female issue, and if the trial is not about that, we're able to redact those things. They argued that our redactions of the medical records were not in the right color. We had redacted ours in white, and they said they had to be redacted in black. Essentially what their strategy was there is they wanted it to look to the jury like we'd hidden a bunch of things. In any case, they fought us tooth and nail on every little thing. The gamesmanship got so ridiculous that at one point in the trial, they had an expert that was supposed to come in. And it was near the last day of trial. And they said, Judge, our expert can't be here today, but he can be here on Monday. And the judge, to our surprise, actually said, okay, fine, everybody go home, we'll come back on Monday. Literally made us miss a day of trial, which is highly unusual. But there weren't many rulings going our way in this case. For some reason or another, the judge just didn't see our case very favorably. This was one of those examples. She let everybody go home, come back on Monday. We get back on Monday, and what do you know? Their expert still couldn't come, so they just wanted to go ahead and move forward with closings. It was that kind of gamesmanship. So what we did is we prep all weekend for their expert. We work our tail off. We waste hours and hours, and they knew all along they weren't bringing that expert. But just another ploy to keep us from prepping and trying to win. So we faced that as well as another obstacle. And then I would say the last obstacle that we all know exists, or some of us know, at least as attorneys we all know it exists, but as doctors we don't, and certainly not as clients and not as a jury, is the jury doesn't know that insurance is involved. We're not allowed to say, State Farm Insurance or Allstate Insurance or USA Insurance is not paying this claim. Instead, we have to make it look like we're suing the person sitting at defense table, the counsel's table. It's not them, but the jury sometimes looks over there and they get, kind of soft-hearted and they feel bad for that person. And in this case, that's what happened. We had a delivery driver. He was a delivery driver for a parts house. The guy clearly wasn't well off, clearly had made a mistake, but the jury didn't want to punish him. And I understand that. They have a soft heart. But what they don't realize, and what's so unfair, is we're not punishing him. The company bought automobile insurance for coverage just in case something like this should happen. If someone was injured, they would be taken care of. But there's this impression in the courtroom that we're suing this poor person. And again, that makes that hurdle that much higher for us. We have to get past, the whole, it's just an accident, poor guy thing and prove, no, what about Miss Keller? What about our client? What about all she's gone through and she's going to go through? So now let me jump into the case itself and tell you about Ramos Law's involvement. And let me tell you a little bit about my trial partners in this. First, our team consisted of Jessica McBryant. Jessica was our lead trial attorney on this case. She was first chair, as it's referred to. And man, she did an outstanding job. It was her first trial as first chair, but let me tell you what. She had done enough trials and had enough experience being second chair, meaning being alongside someone else who was leading the show, that you could not tell. She did not miss a lick. Her work ethic was absolutely incredible. She had perfected our jury instructions and then redone them. And this is what goes to the jury and what they have to base their decisions on. She did our opening statement and our closing statement. She carried a massive burden of work, and she did it because she wanted to, and she did a great job on it. Her opening was incredible. Her closing was incredible. She concisely summarized points. She really made it clear what was going on. She was fantastic to work with, and I enjoyed every bit of it. And even more so, and I think that the jury really saw this, Jessica has an incredible amount of empathy. She cares so deeply for our clients, and that comes through, and it comes through in the work that she does and her work ethic. The second member of our trial team was Randy Manning. Randy, he is the managing partner of this firm of Ramos Law, and he is for a reason. He is seasoned. He has a lot of trial experience, a lot of deposition experience. He thinks on his feet like nothing I've seen. And I've seen a lot of attorneys in trial, and you'd have to see it yourself to really know what I'm talking about. He's very analytical and on the spot, and he can just tell how to get past the BS. As an example, at one point in this trial, they had that video I mentioned earlier that they wanted to play for the jury. They showed our client out there sweeping and getting, spider webs down from up in the eave of a outside porch and carrying in these groceries. And she was bending and twisting and reaching. It did not look good. That video alone could sway an entire trial the wrong way for us. I would call it devastatingly misleading as a physician, and I want to talk about that in a minute, because anybody can do anything for once or twice or a little bit of time. What do they look like at the end of the day, or what do they look like the next day after doing that? And videos don't often show that. And here's what Randy did, just as an example of his experience and his way of thinking. Rather than arguing that this video was biased or that it showed things that weren't fair, which all would have been true, Randy said, Your Honor, this video hasn't been properly disclosed. They should have disclosed, rather than disclose us hours worth of videos, they'd followed our client for weeks. Rather than disclosing hours worth of video, if they're only going to show certain segments, if they should have disclosed that, the reason they disclosed it all is they're playing hide the ball like they've been doing this whole time. They just, so we can't tell where they're going to pull from. We have to watch days worth of video to find out what are they going to do? What are they going to throw on us? And this approach, he backed it with case law argument, and he pointed out to the court how it was unfair to our client, and it was unfair to us that they had done that. And to our surprise, because we didn't win very many rulings, we won this one. And the judge said, that video is not coming in. You're not going to ambush them. That was a big turning point in the trial. And the way that Randy's skill in doing that came through was incredible. Another place I saw Randy think on his feet was this. In the opening statement, the other attorneys had said, this poor driver here, he just slid out into an intersection. He hit his brakes and he slid out. The roads were slick and it could have happened to anybody. And, accidents happen. He's just a parts delivery guy. Well, Randy got up there and was able to prove that he was driving a full-size, 1-ton Chevy 3500 truck, I believe, with a gooseneck flatbed on it, with a loader bucket on the back of it, and how many ton the truck and the trailer and the parts delivery guy wasn't some Napa parts guy. He literally had parts of a loader on this trailer. It was a heavy load. Randy also went into, what year was that truck and what are ABS brakes? And you could almost see during this time the jury kind of going, oh, the light turned on for him. ABS brakes, of course, prevent you from sliding, prevent you from being able to lock it up and make a bunch of marks. And he had lied. He didn't slide. They'd exaggerated in their opening statement. And basically, Randy was able to use some, and I could give you many points, but he was able to use some points like this that were small points, but became very big points because it showed the dishonesty of the other side. It showed what they were doing. And I really think that ultimately swung the ball for us in this case between Jessica and the things I mentioned with her and then Randy with those things and how this case went. Now, my role as an attorney in this case, I always wanted to say as a medical doctor, it was because I took on the medical doctors. I think there were 3, maybe 4 medical experts in this case, and I handled all of them with their direct exams, redirect of them. Any medical testimony in the case fell on me, and that's right down my alley. I speak their language. We speak the same language. I've testified in court over 100 times as an expert personally, and I've written numerous expert reports. All that as a medical doctor. And so I know where the doctors are going to go, and I know where we need to go. And that's a difficult thing, and I want to speak to doctors here in just a minute how difficult that is. Sometimes with doctors, they can't just give you the straightforward answer. I wish you could ask them, is the sky blue? And they say, yeah, the sky's blue. Instead they go, yeah, sometimes. Clouds do come in. Well, is the sky blue right now? Yeah, it's blue right now pretty much. I might call it a baby blue. They kind of answer like that. It's just like, can you just say, yes, the sky's blue? That makes cases very difficult. And in this case, I had to walk through these doctors through this because I've been there and I know where we need to get. And that's a challenge. We had a particularly challenging thing in this case that associated with the injuries. There was a hip injury in this case. Now, how do you get a hip injury in a car crash where you get hit to your driver's side of your vehicle? And you have to explain that to a jury, especially when they're inside the car, a compartment. There's no airbag necessarily that went off. How did the hip get injured? And as one example that I was able to do, and this is where I think the medical knowledge as an attorney really helps, is one of the areas when you get a labral tear in your hip, one of the areas or ways you get that, and the most common way to get that, the hip is at most risk when it's in flexion. Flexion is if you pull your leg up like this, and internal rotation, okay? So those are the two areas that the hip is most at risk, the labrum is, and most susceptible to a tear. So I had this orthopedic surgeon up on the stand, and I was trying to get him to say, this hip injury happened in this crash. And I couldn't, was that same kind of sky is blue analogy I just gave you? I couldn't get him to say the obvious. So I just said to him, doctor, now at what position is the hip most vulnerable? And he said, oh, flexion. And I said, and how about labral tears? What type of rotation might cause, would be more likely to cause injury? He said, oh, flexion and internal rotation. I said, okay, doctor, when you're sitting in a car, how is your hip? And he's sitting in his chair and he goes, oh, yeah, your hip's in flexion. I said, okay, and if you get hit to the driver's side of the car and your hip, which way would your hip go? And he goes, oh, it would internally rotate. I said, so is it more likely than not that her labral injury was hurt due to the flexion and internal rotation of her hip from this collision? He said, yes, definitely. But it took that kind of walking through, and that was an example of a doctor to doctor getting out an injury that you may not come easily to others. And so doctors are really important. And doctors are really important too to explaining how these injuries then affect people on their job. I've already mentioned that Miss Keller was on her feet a lot. Her job required her to always be up and around. Well, it turns out that her studies, her x-rays and her MRIs and stuff showed arthritis. She was in her 50s, and we all have arthritis after about age 30 or mid-30s. We start to form little bone spurs, little narrowing of our joints. The discs collapse a little bit in the spine. The hips get a little bit narrower. The joint fluid in any space like our shoulders gets a little bit smaller. That's why we're more predestined, so to say, for injury. But we also have these changes that you can see on films. This becomes a huge issue for us to overcome in trial, because many times they want to say, it wasn't the injury that hurt this person, it's them. It's their baseline health. Now, we get in trouble, stuff like this, because you can get yourself into a damned if you do, damned if you don't kind of scenario. Because if you don't acknowledge that they have degenerative changes, you look like a liar. If you acknowledge that they have degenerative changes, it looks like you're saying, yeah, that they had a problem beforehand. It's not that at all. Most all of us have these degenerative changes, and we're going around pain-free and having a full and normal day. We're just more susceptible to injury once it occurs. So it takes walking the medical doctors through that process and going through what it takes to qualify an injury. In law, we call it specific causation, not just general causation, not, oh yeah, the crash can cause injury, but rather the crash did cause the injury. And you have to walk the medical experts through that. And I think I know, it takes a lot of time and it takes a lot of understanding with your experts to get there. So we were able to get through that. We were able to explain how, if she had these degenerative changes, she could work with, for example, on those freezers for those long days, how she was able to get about, but still be injured. Now, here's some points I think about this case that are unique to our law firm. And I'm about to wrap up here, just a few minutes left, but I want to tell you some things I think are unique about Ramos Law and what I got out of this trial. What really came to me, and it means a lot to me. And the first thing is that, just like I said, defense attorneys will do whatever it takes to win. Some of them, we will match it with that every step of energy of we will do whatever it takes to win and get the truth out. So in this trial, for an example, we sent 3 attorneys there, myself, Jessica, and Randy. We also had another attorney who was new to our staff, and we wanted him to get broken into trial and what it was like, what the environment was like. So we had him show up to help. And he was in the back, getting exhibits ready and handing us things, didn't do anything, didn't question any witnesses, he didn't enter an appearance, but he got to watch and he got to learn. And that's 4 attorneys from our staff there for this trial. Now, we don't charge extra because the attorneys are there. That's not how it works. We get the same amount whether there's 1 attorney or whether there's 4 attorneys. But why we do it is because we want to make sure that at every corner we're prepped for each witness. At every corner we get the input of our fellow colleagues. At every corner we're ready to address something they throw at us. For example, during this trial, Jessica wrote 3 or 4 motions at night that had to be filed by the next day. It takes a team to do that. That costs a law firm money, but it's important because we're talking about people's lives. We're not talking about money, we're talking about people's lives. We don't charge extra. It's just the right thing to do. And here's another example. In this particular trial, we had a psychologist in the back that we brought, and we had him watch from the very back row of the courthouse and just take notes all day, every day. That's all he did. We paid him to be there. Now, why would we do that? Doesn't seem cost effective. It absolutely is cost effective. It's called doing what you need to do to best represent your client. We needed someone with an open mind to tell us at the end of each day, at the end of each break, at our lunch break, after every witness, whenever there's a break in things, we needed someone to tell us who was neutral and open-minded what they were seeing, what they were hearing, what we were presenting, how we were coming across. You see what happens, and attorneys out there watching this will know, we get so into the trial, we get so deep into it with our clients, we get in the woods and we can't see out. We don't get that perspective. And we wanted someone there who could tell us, and man, did it help. He continually pulled us back and said, hey, here's what you're missing. Hey, here's what I'm seeing the jury. Here's how they're acting. Here's what I don't think they understand. Here's what I don't understand. When he would say that, I'd be like, oh, that's a huge point. Again, it's expensive, but what price can you put on a person's life? And that's how this was for Miss Keller. This was her life before her. Now, when it comes to medical doctors, I wanted to touch on something, and if any doctors are watching this, please remember this. The kind of sort of approach, I call it, the well, could be, could not be, this isn't the place for it. The jury understands that you're smart. You're a doctor. The jury understands we've qualified you as an expert. They're seeing you as an expert. You don't need to sound smart. You need to come across as approachable and real and truthful. And kind of sort of doesn't do it. It muddies up the water. That benefits the insurance companies so much you won't believe it. You see, we need to prove that the injuries came from the event in question. We have to prove that. All they have to do is poke holes in it and hurt our case. And when you have a doctor who won't give a straightforward, full answer, just a pure yes or a pure no, and he makes it sound like, well, occasionally, it's misleading and it doesn't get out the truth. You know, this sometimes happens. I just had a doctor do this to me in trial. I get him up on stand, and I ask him about a condition that I knew occurred from this. He goes, well, not always. I said, oh, really? Really, doctor? Like, how often not always like this? Well, it's just not always. I said, like 1% of the time? He said, yeah, it's about 1% of the time. I knew the statistics on it. I'm a doctor. He said, it's about 1% of the time, but it can happen. Well, the jury, you could see them. They went from at first going, not always, going, oh, what's Dr. Ramos doing here? He didn't quite get this out. When they heard the 1%, they all started smiling. It was like, oh my gosh, doctor, 1% of the time? That's an example. If you're a doctor and you testify in these cases, be straightforward, be clear. We don't need the exception. We don't need the, that 1 in 1,000 thing to make you sound smart. We just need, did it cause it or did it not? And many times it's a lot more straightforward than doctors make it sound. Again, I think the defense attorneys already have the easiest job in the room. Imagine just being able to poke holes. It's like being a backseat driver. Other side has to go first. You hear everything they said. Just poke a hole here, poke a hole there, poke a hole there. Make it sound like they're out just for money. Talk about the degenerative changes. Talk about the arthritic changes that the person has. Make it sound like, oh, they're saying their life's so bad. Look at their walking. They could walk for 18 hours this day. Of course, you don't tell the truth about the next day. You don't tell the truth about the rest of their life. You don't tell the truth about how much more rapid their bone surfaces are going to degenerate and how much worse their arthritis is going to be or how they might need surgery sooner. You don't tell any of that. You don't have to. Poke a few holes. That's the deal for the defense attorneys. I think for doctors, it gets to be this. I think the reason that they sometimes aren't as straightforward is they get all the time dealing with so many situations of people with pain and with injury and such, they become a little bit callous. They lose their sensitivity. And I'm not blaming, I'm speaking from my own heart. I had to go through this as a physician to remind myself that this was a person. This was a person in their lives. This was not a number. This was not what my schedule showed that day or something, or not room 8 in the emergency department. This was a person with a family. And I think for attorneys, it's the same way. Are these cases or are these clients? They're clients. And people can become callous with so much time, and we become callous as attorneys. They don't prep the experts well. As doctors, they just don't answer straightforward. They start to take things personally instead of understanding that we're here to serve. And so we need to tell our clients stories. And in this particular case, in the Keller case, we're able to do that. We used our medical strategy to drive our legal strategy. The two worked perfectly together. And you know when you've done a good job, a really good job in a trial when this happens, and it happened in the Keller trial. We were about 3 or 4 days in, and the attorneys came over to us at a break, and they said, hey, we'd like to talk to you about an offer. Oh, an offer? Sure, we'll listen. What do you have for us? So they offered us $1 million in the middle of trial. What happens when they offer money like that? If you accept it, the judge just goes out and says, hey, ladies and gentlemen of the jury, a settlement's been reached and you can go home, and the jury never knows what happens. That's what happens to the jury. For your client, here's what happens. They never know if they would have won or they would have lost, but they have a no-risk proposition. I say no risk because they have that offer of that $1 million at the time. They've been beat up all week. They've had their confidence slammed. Their arthritis has been talked about. The stuff that makes them look like a faker has been talked about. Anything ugly has been talked about. The holes have been poked. And sometimes at this point, the clients become fearful, and the fear begins to run the show, and they just want out. It's good for us as attorneys because we know if you get an offer mid-trial, the other side, who also had 2 people in the back watching them, an adjuster and an appeals attorney watching them from behind, they were getting told by their people, their guidance counselors, if you want to call it that, hey, we're getting our butts kicked. We better wave the white flag. Mayday, mayday, mayday. And they were offering $1 million. Now this gets really tough because at this point in the trial, it's really about a 50-50 proposition for our client. Even if you're doing a good job, you never know when someone on the jury isn't in your camp, or you never know when someone on the jury isn't going to give you what you feel the damages and the injuries are worth. And so it's challenging. And this is where knowing your client and having a great relationship matters. And I'll tell you, in this case, Jessica had such a great relationship with the Kellers. Randy and I had developed a relationship with them, but nothing like Jessica. She knew them and she knew them well. She was personal with them. They trusted her. And they expressed that trust when they came out and said, no, we're turning down the $1 million. Now, ultimately, with the interest and the fees and the cost stuff, we got about maybe close to $1.1 million. So ultimately it benefited them by about maybe $100,000 to turn that down. But man, what a risk they took. But they loved Jessica, and they could tell how much she cared. And I'll tell you, for me, it solidified for me, this is a person I want to work with. And it was fantastic. The personal impact on me for this trial was that solidifying that relationship with my team, seeing Randy Manning on his feet, get out evidence that was so incredibly difficult to get out. These trials are emotional. You care for your client, and you care for them a lot, and it can really lead you into making mistakes and not being clear. Trials are also trying physically, mentally, emotionally. The reason is you get up about 5 in the morning, you get ready by about 6, you travel to the courthouse, usually about an hour or so there, usually meet with your clients a little bit. Trial starts up at 8 a.m. You finish about 5 to 5:30. About 6 p.m., you get out of there after you're done talking to your client. You drive about another hour home. About 7, you get home. Then you eat. You talk to your family for about 8:30, maybe 9 o'clock, and then you start prepping again for the next day. You prep for the next day because it changes every single day. You can start your prep weeks and months before, and you should, but it always changes all the way up until that day, where they're going or what they're doing or what their strategy is. You can see it coming. So you're re-prepping, rewriting, redoing, and you'll do that till midnight or 1 in the morning, and you're back up again at 5. And you're going through that same thing. About day 3 or 4, mentally it gets hard to think clearly. Emotionally, it gets hard to be involved. There's sometimes these feelings of frustration, anger, anxiety, even joy, all mixed in together, all in the middle of being incredibly fatigued. And so for our clients to have faith in Jessica and in us at that point was really, really was satisfying. That's something personally I'll always remember, and I will always be thankful for my team. It really showed me the substance of who I work with. I have always wanted to just work side by side with people that care about other people as much as I do. They care about our clients as much as they care about their families. And I've seen it otherwise. Unfortunately, firsthand as an expert in those trials I told you I've been a part of, where you show up and the attorney, they didn't prep you, and they probably got 8 hours of sleep. They come in and it's just kind of, we're going to wing it and see what happens here. They ask questions without you even knowing which direction they're going. And to me, those are attorneys who really don't care. They didn't really take that time. They didn't put in the work. They didn't put in the prep. They didn't put in the time to do what was right. I've always wanted to be side by side with people who do what's right. And in this trial, I did that. Jessica and Randy were incredible. Our team was prepared. All I can say is, wow, we were prepared. The work ethic and the caring was second to none. And it made me proud to be doing what I'm doing. You know, in ending, the justice system is not always fair. You could improve your odds at getting fairness by going with the right team. And I can tell you here that we have one by one, we've built a team of winners. We've surrounded ourselves with a team of people who care and care deeply. And this trial was evidence of that. It makes me proud to be doing what I'm doing here.